not need one. One run.
521.
Starting a card for a parking problem.
10-4 in your 23.
Yeah, 10-4, I'll get a 28 from one truck when you're ready.
Go ahead.
One truck, White Lincoln X-ray 985 should come back up and
So you had 2000. Patrick Spalding.
10-4, if you can just put a little note in the, something like that, I'm going to be leaving a note on the vehicle so they can remove it.
Fine. Fine. Rockingham 505. 505 ended up vandalism case for Athens. Complainant, soon to be ex, slashed her tires and has made threatening comments to her. She's concerned he might return.
And forgive that to 32.
10-4. You're assigned to a vandalism case in Athens. Did you copy the 505?
Yeah, 4. Look at that.
21.
No, 3 in Depot Street. Truck boy entry 5.
7435.
10-4.
10-4.
You go 643 again.
143.
You go with that 43 you had. I didn't hear any, but I had just looks like we do.
10-4, I just wanted to know if you should be put back 76 to Cabana Circle or to the subject's address.
Yeah, I'll be 23 back on the town property case, and I'll be 76 to the Williams Road address to see if I can find the owner.
10-4. 449 1120.
Now 449 1121, thank you.
10-4.
Code 4. 4.
Rockingham 535.
Yeah, that was a great college.
535.
Should be. Got no for a woman who fucked into a house. I'll slide up that way.
Caller is now able to close the front door, now pounding on the door, trying to get it still. No,
have separation. Inboard now. She's waiting.
Hey guys, good evening. Thanks for being here. Obviously, I didn't expect to be back so quickly, but we had a new motion today. So we're going to go over that. This is a motion to exclude the testimony of defense's forensic data expert, Rich Green. So I first want to just begin by thanking Tom CPU and anybody else who decided not to go to the funeral, did the right thing, and should be commended for that. That's what we need to see more of, as people trying to do the decent thing. So let's just end it there. Thank you, everybody, for being here. I want to thank my moderators. First, Tom Fleming, who's been with me not only since the beginning, but really since before the beginning, since we've been friends for many, many years. And then obviously Joe, who's been a great addition to the team. So thank you guys for being here. Very much appreciated. Sometimes it can get a little rough in there. I also want to thank people who send me clips from some of the other shows. So, and we're going to have, I don't usually mention their names just because I never know if they want to. Everybody, you know, the way this world is in this case, everybody wants to be anonymous for understandable reasons. So, I do want to mention that. So I was sent a couple of clips from Melanie's show. I don't know if she's responding to this criticism. I'm not, we'll see. I haven't even had time to watch them yet. So we'll watch them together, but thank you for sending those to me. So I do appreciate it because I think they do add a lot to the show. So, for those of you guys that do that, thank you very much. So let's get right to the motion. And I think, again, I'm not a lawyer. This is just my amateur analysis. Oh, good. This is a form I can make bigger. Excellent. This to me seems to reveal the strategy behind Hank Brennan's initially filing the motion on Dr. Russell, which, and not only on Dr. Russell, but even to go after the parents' phones. I don't think there was really ever any chance that they were going to get the phone data on Mr. and Mrs. Reed. The courts don't allow that kind of fishing expedition, and Hank Brennan certainly knows it. He's one of the best lawyers around. So when he's doing something, we have to ask ourselves, what's the real game? Because he's not doing something because he doesn't understand the law. And I don't think he's generally just taking long shots here, although that's possible. I think there's a strategy. And so I personally think that the strategy here is he reads Judge Cannone the way that many of us read Judge Cannone. Certainly, I know I have said this before. She is kind of like if you have a kid, if you're a teacher or you have kids or something, and your kids are having a dispute. Maybe they're who gets to use the PlayStation. And Judge Cannone, the parent is going to say, okay, you get it from 10 to 12, and you get it from 12 to 2, and you get it from 2 to 4. Judge Cannone seems to always want to have that split decision. It's not that it seems to be extra meaningful to her. Maybe because she's a mom, right? I don't even know if she actually know that she is. I'm assuming that she's a mom. She definitely comes across as the mother of the court. That was an expression I think that Kerry Lama came up with, and I thought it was very apt that Judge Cannone presents herself as the mother of the court, and the jurors respond to that, and they feel under that protection. So I think the downside to that, though, is that if you're going to call balls and strikes, let's compare it to an umpire. And an umpire should be calling balls and strikes based just on whether it's a ball or a strike. But in reality, if you're an umpire, and I used to play baseball and softball, if you get a close call or two to go your way on a borderline pitch, well, the umpire is remembering that. And so they're maybe a little bit more likely to give the next borderline call to the other side, just as out of a sense of balance, you know. And I think Judge Cannone has an extra strong inclination to be that way. And so if you have something that you really want out of the judge, but you know it might be somewhat of a close call, well, then it makes a certain kind of sense to send her something that is also somewhat of a close call, but you're not going to get. That way, you're more likely to get the close call that you want. It's just a strategy. I have no access to Hank Brennan. I don't know what his actual strategy is, so I'm sure it's something very different than what I just said. But this seems to me is something that I think could be a possible strategy on the part of Hank Brennan. And if so, it strikes me as a good one, right? So I don't think there's any chance that Dr. Russell is going to be excluded. It's not because I buy into her explanations or her credibility, but there's enough there. She had a methodology of discussing why she believes that these are dog bites. She's really evolved her position on that with the help of the defense lawyers, it seems. But so now she's talking about the threads being outside of the shirt. And she's saying, so this is something broke through the shirt, damaged the surface of the skin, and then withdrew. And that's why the threads were pulled out. Now, I don't know if there's any validity to that at all, but it sounds at least like a reasoned argument. She's not just looking at something and saying, dog bites. She's giving you some kind of a rational explanation, and it's based on her experience. So it's very unlikely that that's going to be dismissed, in my amateur bartender opinion. All right. So I think Hank Brennan knows this too. Now, there could be other reasons too, like you're getting her on the stand, and maybe some of the statements that she makes during the Dauber hearing will come back to haunt her during the trial. Maybe. But, there's another disadvantage too, is that now you have she gets to practice her pitch in front of in an actual courtroom. And every time she does it, it's going to get better. I mean, I can tell you someone who, does videos, that if you're doing a video on a certain specific topic, each time you do it, it's going to improve. That's just the way it is. That's just how things are in life. So now Dr. Russell is going to be she's improved quite a bit now from what she was in June. Well, she's going to improve again between this April or May, whenever she comes on. So that's the downside of having this Dauber hearing. But I do think now we see the potential upside in this motion for excluding Rich Green, because I think there is a better chance of excluding Rich Green here. Now, that said, we have to keep in mind that any judge, it has nothing to do with her being pro-defense or pro-prosecution. Any judge is going to be very careful, does not want to be reversed on appeal. So that's something that's going to end up making every judge seem to be somewhat favoring the defense, because there's not going to be any appeals from the prosecution. If Karen is acquitted, that's it. The prosecution, because of double jeopardy, there's no way that the prosecution can say, but what, you made a mistake on this. No. But however, on the defense side, they can use that to get a new trial. So any mistake like that. So the judge is always going to be very, very careful. Any judge is going to be given things a little bit noticeably towards the size of the defense. But that said, I do think there's a chance that Brennan could succeed here and get a Rich Green thrown out, because there really are questions about his credibility, his methodology. So let's go through this motion here. And I also have lined up after this, if you guys want to watch some. I watched yesterday, I rewatched Rich Green's testimony in the trial. It's not super long, and I'll put it on 1.5 times speed, so we can and there's certain parts we can skip through too. But just to give you guys an idea, refresh your memory. I know many of you guys watched it. All right. The Commonwealth respectfully moves this honorable court to exclude the proposed testimony of Richard Green relative to 2 issues: the claim that Jennifer McCabe's phone Googled how long to die in the cold, and naturally there's a spelling mistake, or how slow. Maybe that's how it was original. Google. So Jennifer McCabe phone Googled how long to die in the cold, or how long to die in the cold. So I guess the mistake was on the part of the way Jen typed it in. Anytime prior to 6:23. So that's one basis for trying to exclude his testimony. And two, that Jennifer McCabe's phone incurred user deletions of any data related to Google searches. So they're just talking about the Google searches here. So the defense made a lot of claims that Jen was deleting phone calls, deleting Google searches. So they're disputing it. This specific thing, we know that Ian Whiffen, I think it was Ian Whiffen, but it might have been Trooper. It was definitely explained, might not have been Whiffen, but it was explained by one of the experts that there was no, Jen McCabe did not delete any of her calls. This was just, you get deletions that go on inside your phone, invisible to you, when your phone is rewriting that information to another folder. And so the folders that stores calls only stores so many, and then when it runs out, it deletes and starts up another folder. That's my best bartender explanation for it. It's the best you're going to get. All right, so exclusion. So excluding this expert witness, this expert is appropriate because both claims lack any evidentiary support, and the claims cannot be made in good faith. Allowing introduction of baseless claims without any scientific, forensic, or factual support would be misleading to the jury and disruptive to the interest of justice. The Commonwealth's expert, Ian Whiffen, is Celebrite's senior digital intelligence expert and an expert in digital forensics. He has engaged in a comprehensive analysis of the two above claims lodged by Mr. Green. His analysis has included the implementation of forensic data science, personally reviewing the device data, properly and accurately employing Celebrite technology, and a study of materials generated from the device. After a comprehensive study of the forensic data and consideration of Mr. Green's claims, Mr. Whiffen's opinions disproving Mr. Green's claims are unequivocal. Mr. Whiffen provides, now, I haven't read it, I don't have access to it, but I guess there was a white paper recently submitted, or at some point not too long ago, by Ian Whiffen that went out to, I'm not sure, it may have, if it just went out at this point to people involved, or if it went out to law enforcement more generally, people that use this tool. It's law enforcement that uses this tool. Celebrite is designed for forensic analysis of devices. So it's not something that the average person wants to use. So Whiffen says, and this is in quotes, I can state with absolute certainty that there is no evidence whatsoever on this device that the Google searches, how long to die in the cold or how long to die in the cold, occurred prior to 6:23 a.m. Moreover, Mr. Whiffen concluded that there is no evidence that the user tried to delete any search history or that tampering occurred with any of the data that I examined. Consequently, Mr. Green's testimony on these two issues is wrong, factually unsupported, and should not be admitted at the jury trial in this manner. The underpinnings of Mr. Green's testimony on these two issues fails to meet the requirements set forth in these couple of cases. Which in these cases they say the conclusion was the defendant cannot meet its burden to demonstrate. So he has extrapolated from these cases that the way they should be applied is that Green should be excluded because the defendants cannot meet its burden to demonstrate that Mr. Green is qualified to testify to these two opinions. Now, when we watch Rich Green's testimony, we'll get to see that because he was asked about his qualifications, pressed on it by Adam Lally. And his answers were somewhat interesting. So Mr. Green's opinions do not meet the minimum requirements of digital forensics and lack any scientific basis. And 3, Mr. Green will be unable to provide any facts to support his previous testimony, which has been completely discredited relative to these issues. Now, I should say, when I talked to Turtle Boy on the phone a year and several months ago, it was after the day after I had really had they call it the outburst episode or something, when I really went after him hard because he was in chat accusing me of both sidesism. So I accused him of being a shill for the defense, essentially, and getting all his information from the defense. And he called me a liar for that. So I called him on the phone to try to clear the air. But I didn't take any of that back. To me, it was just self-evident that he was talking to the defense. But we did spend about an hour talking about the case. And one of the things that I asked him was, who is this Rich Green? I cannot find, because we could not find, and we had several people on the team looking into this then, anything on this guy. Any case, we had a website, and you go to his website, and it doesn't tell you any case that he's been involved in, any qualifications he have. It was the simplest bare bones website you could ever see. It just basically has his contact number. So did this guy ever work a case before? Maybe he did. I don't know. So I asked Turtle Boy this. I had actually reached out to Alan Jackson too. He didn't respond, but I said, give me something I can use on Mr. Green, Rich Green, to show me who he is and what he's done before. Because at the time, we didn't have Ian Whiffen, but the state was producing Jessica Hyde, and you could look at her qualifications, and she was the best of the best. And you could read a long list of her work. Couldn't find anything on Rich Green. So I said, so Jackson didn't get back to me, and I said to Turtle Boy, what can you give me on Green? And he said, he's certified. What can I tell you? I said, yeah, but has he handled anything? He goes, I don't know anything about him. He said he's in his 70s, and he was certified, I'm going on memory here, maybe in 2008. So what did he do for his life before this? Did he, was he a cop that retired and went into this? I don't know. I still don't know. We don't know anything about his qualifications. So, all right. So on June 21st, Mr. Green testified on behalf of the defense. Mr. Green purported to be a forensic expert specializing in computer, cloud, surveillance systems, and other systems. Mr. Green testified that he was asking to parse through data from phones belonging, that he was asked to parse through data from phones belonging to Jen McCabe, Karen Reed, and John O'Keefe. He said the Google search. Now, I want to say, too, just here in response to, maybe this is a good time to address it. We'll pause here. Let's pause for a commercial. No, I will take a sip, though. All right. I played that clip the other day of Melanie Little a couple of shows ago. And Melanie was saying that, and her little kind of making her face twerking stuff and not really making an argument and just saying something as though it's a fact. She says that Karen's phone was wiped of its location data, its GPS. She just states it as though it's a fact. Now, no one has ever made this claim before. Karen, in a year and a half of all her leaking and all her interviews on TV, has never said that. Now, keep in mind, Karen is obviously in direct communication with Melanie Little. Karen has never said that before. Her defense didn't say it in the trial. They didn't say it in their opening arguments. They didn't they didn't say it in the closing arguments. Now, it would have been huge to the defense. It will be huge to the defense if that was true. And this would have been the headline news. Phone data wiped, because if her location data was wiped, it's potentially exculpatory, right? Because the state was accusing all the way back when it first charged her with second degree, they were accusing her of returning to the scene of the crime. So if her GPS data was on, you could almost prove by that location data if her claim was true. If she claimed that she didn't return, you'd have that proof there, right? Not completely, because there's always the possibility that she was clever enough to leave her phone at John's house and then go out looking for him. But it still would be very exculpatory if that phone never returned to the scene of the crime. So if that data was wiped, that's something that'd be the top of the story for the defense team. But they've never said that, not once. Okay. But as I said on my show, when I first saw that clip, I said, I doubt that Melanie is just making this up whole cloth. There must be something that she's exploiting there to say that. And we're going to see this when I play that clip. When I go through the testimony. So I went back and I watched it the next morning to see. And I went all the way through. So I watched both the direct questioning by David Yannetti and then the cross by Lally. The defense never asked Rich Green anything about Karen's phone. Nothing. They didn't even ask if she looked at it. They definitely didn't ask anything about the location data. Zero. However, fortunately, I kept watching. When Lally came on, Lally did, for some reason, ask about that. And we'll see Rich Green's reply. But that's the point where he said something that would give Karen and her minion, Melanie Little, some basis for saying this. Okay? But whatever, it was not strong enough that the defense noticed it even. So they either didn't think that what Rich Green said was credible, or somehow they just didn't even notice it, which seems bizarre to me, right? Because you would think that after that question, David Yannetti would come back on redirect and say, "Are you telling us that Karen's location data was wiped out?" But actually, David Yannetti chose to not even ask any more questions, and it ended there. So very strange. And then, as everybody knows, in the closing, there's no mention by Alan Jackson of saying, "And my client's location data, which could have been exculpatory, was wiped. What is going on here?" That wasn't in there at all. So it's only now, after all this time, that suddenly they have found this, right? And we'll see exactly what Rich Green said on that thing there. So let's get back to this now, and then we'll get to that later. So let's see. Green said the Google search was found in a write-ahead log. Was it Green said? Yeah. Green said that Google search was found in a write-ahead log where data is stored temporarily before it is written into the main database. Mr. Green claimed, quote, "Just by the nature of it, we'll find a lot of the newest artifacts in that WAL file." Mr. Green also proclaimed that the search was in a deleted state. He testified that he found a lot of other user-deleted artifacts in McCabe's data from the morning. Now, again, we got a lot of testimony from the state's experts that said there were no deletions. So, and in a battle of resumes, Rich Green is nothing, and Jessica Hyde and Ian Whiffen were the best of the best. Now, some of those statements did also come from Trooper Garino, who, and I'm not proposing that Garino is an expert. He's a state trooper that's been qualified to do this work. On April 11th, 2023, so this is, all right, bring back the clock. On April 18th, 2023, this is when this case, the Karen Reed drama, began for most of us, including me. That's when Turtle Boy published an article that put out the defense theory on April 18th. And that's what made this the big story that it became. Well, on April 12th, so less than a week before, that's when the defense put in their motion for Brian Albert's phone. And in that motion, that's when they detail their conspiracy theory. So the day before that, Richard Green put in an affidavit on behalf of the defendant, opining that search history information obtained from Jen McCabe's cell phone indicates that on January 29th at 2:27 and 40 seconds, the phone's user entered the following search: "House long to die in the cold." Mr. Green testified at the defendant's first trial and rendered a similar opinion, claiming that certain phone calls were user deleted. So again, he does mention here user deleted in the opening paragraph. They just talk about Google searches. But during cross-examination, Mr. Green was broad and vague about his training, experience, and lack of digital forensic certifications. So we will see that. And I don't even want to pretend to know how much that matters. It may matter a ton, and it may matter not at all. When they asked Rich Green about his certifications, he didn't really seem to have any. But that doesn't mean he wasn't qualified by taking all the courses or whatever. I don't know. Mr. Green conceded during his trial testimony that Cellebrite modified their software based on his misinterpretation of data from Jenna McCabe's cell phone. Now, I should point out here, again, I got to be objective, right? I know people can get mad at me. I did not see, and you're not going to see when I play this here, Rich Green apologizing to Jen McCabe or changing his mind on any of this. Well, all he says is that, yes, I understand that Cellebrite changed their program as the result of this case. That's not the same as saying that he believes that his interpretation of the data was wrong. So, kind of a different thing. Despite knowledge of his error, Mr. Green is yet to submit a revised written report or opinion. Now, I'd be interested to see. I suspect that he has not changed his mind because this is the nature of the beast. This is the thing. So, same thing when we look at the ARCA guys or we look at Dr. Russell or, frankly, people on the prosecution side, too. It's human nature for people to stand by their original assessments. We can call it confirmation bias if you like, but that's really something different. This is more of an ego thing where you've put your reputation onto something and you're going to stick with it. And it's kind of hard to see these guys change their mind. So for instance, the ARCA guys, what are they going to do here? Now, I think the ARCA guys at least have an out. They can say, these are the accident reconstructionists hired by the feds. The ARCA guys can say, well, you know what? We did the best we had with the limited data that the U.S. attorney provided us. But now that we have more data, we can see that John was struck by a vehicle. Now, I'm not saying they're going to do that. They may not do that. But at least if they are somewhat inclined to do that, they have that excuse of saying they didn't get all the data. Rich Green has that a little bit here, but again, he's a guy that was hired directly by the defense. So I don't, if this works here, he's going to be in demand for a lot of money for a lot of trials because data is all around us, like in the movie The Matrix. Just picture all this data stuff around you, right? It's in our phones. These programs are always changing. Something like Cellebrite has to continuously try to be up to date in order to try to read these layers of data within these programs that are always themselves changing. And they're going to be changing even faster now because there's more apps involved and there's most of these apps and the coding is going to be done by AI. So it's going to be a lot more, there's going to be a lot more updates. So it's going to be that much harder for Cellebrite. So there's going to be a lot of glitches, if you want to call it. There's going to be a lot of instances that if you're going to go data farming, you can find this outlying piece of data that is wrong, but you can exploit it if you're an unscrupulous defense lawyer or an unscrupulous U.S. attorney, or if you're a witness who just wants an expert who's just trying to get paid. So, for instance, in the O.J. Simpson trial, there was a formerly highly esteemed police detective who had been retired for 19 years that testified that he had never seen a police investigation so sloppy as the one run by the Los Angeles police. But it came out that he never, all he ever looked at, he spent a few minutes looking at photos that they gave him, and that's it. He had no basis for saying that. He got paid something like $40,000 for it. A lot of money back then. A lot of money now. It's just the nature of the beast, especially in high-profile cases. You come in a high-profile case, if you look reasonably good on the stand, you're going to be useful going forward to a lot of other teams. There's a lot of money to be mined in it. And what we're seeing through this whole Karen Reed experience is just how rare a quality integrity is. But it does exist. So, for instance, I've talked to Jen Coffindaffer, and Jen is very articulate, so you can see where she would do very well on the stand and be in demand, right? And she's likable, so you could see where defense teams, if they could get her to testify on something in their favor, they'd want it, right? And they're willing to pay good money for it. So these defense lawyers from various cases around the country go fishing, and they send her a packet of the information, and they say, would you be willing to testify for us? But she has integrity, so she will tell them ahead of time, yes, I'm willing to testify on this, but my testimony is probably not going to help you. And so they don't hire her. But what if you leave out that last sentence and you just go in and give them what they want? And this way, that is not uncommon, unfortunately. So I'd be curious to see if Green does file a revised report. It seemed that integrity would demand that he does. Like, even if Rich Green still stands by his conclusions here, given the fact that he's going up against Ian Whiffen, and given the fact that Celebrite did change their program, doesn't integrity require that he write a new affidavit? I would think it would, but I wouldn't. Don't hold your breath. In response to Mr. Green's misconstructions, the Commonwealth retained two experts in digital forensics, Jessica Hyde and Ian Whiffen. During the defendant's first trial, the court permitted a courtroom demonstration by Mr. Whiffen to assist the jury in understanding digital forensic and how the Google searches, I'm just reading it the way it was written, and how the Google searches were stored within the digital databases, specifically the Safari internet browser. And they cite a case here. It says, when digital evidence is voluminous, is it voluminous, Tom? I think it's voluminous. If digital evidence is voluminous, parties should consider authenticating and admitting excerpts when I think it's a jury may find it difficult to master the technology to find and view relevant portions of the evidence. When digital evidence is voluminous, parties should consider authenticating and admitting excerpts. So I guess I'm going to interpret this, and I'm probably going to be wrong, right? So if you have a long, jargon-filled report on something, it makes sense that instead of giving the jury every word of that, which is Greek to them, Greek to us, right, that parties should consider authenticating and admitting excerpts. So, but I'm not sure how that applies to this case here, so let's continue reading. Additionally, Jessica Hyde, a highly qualified forensic examiner, conducted an encompassing review of digital artifacts, file systems, and she conducted independent, peer-reviewed experiments to determine that Jennifer McCabe's phone was in use at 2:27 a.m. when the Safari browser was open and looking at a website for Hockomock Sports. At 6:23 a.m., the same Safari browser was engaged in a new search for how long was conducted when Apple produces a suggestion for how long to digest food. The search is instead completed with how long to die in the cold at 6:23. So this is interesting too. So when you start typing something in, Apple tries to guess what you're asking and provides a suggestion. So kind of like it's smart typing, right? So you can just click on it instead of having to type it out. And what I'd be curious to see, maybe we'll see in the Rich Green testimony, did the program first suggest this how long to digest food, which, by the way, was initially presented by Turtle Boy as evidence of guilt. I want to point that out back a year and a half ago. So that would have been Karen pushing that, or the attorneys pushing that to Turtle. But no, it was Jen McCabe was never searching for that. The suggested search came up from Apple. But if this suggested search came up, if the first time that this came up was at 6:23, that's a powerful indication that no search was made at 2:27 for how long to die in the cold, because I think the Apple will remember the search that you made recently So if you make it again, that's going to be at the top of the suggestions that come up. So but it was not at the top of the suggestions. Instead, what was at the top was this suggestion for how long to digest food. The search is instead completed with how long to die in the cold at 6:23 a.m. A new search is conducted at 6:24 of how long to die in the cold. The different spellings here. This finding was consistent with Trooper Garino's review of the cell phone extraction and with testimony from other witnesses. Just to remind people, so it's Jen McCabe that explained she made that search because sitting in the cruiser, it was Karen herself that asked her that question. And as we were watching the trial, to my surprise, and we all saw this, and everybody had the same impression as me, on the stand, we had a paramedic say, when Karen was on the ambulance, so this was after a second ambulance had been called to pick up Karen because she was being Section 12'd, she asked the paramedic more or less the same question: how long would it take for someone to die in the cold? Which confirmed, which corroborated that's exactly what she was asking Jen. Just to respond to a text from Karen McCormick. So, Karen, I will look into it after the show. I looked into it before, and I didn't find anything with you blocked on it. So, I don't know what it is. You're welcome to come on with us, as you know, anytime if you want to comment that way. You can just let me know. But I don't understand what's going on, why you're blocked. So we'll look into it right after the show. Because Karen McCormick is a close friend of the channel and frequently comes on and is always welcome anytime she wants. So Richard Green's debunked opinions. This is the argument. Richard Green's debunked opinions are not an example of a battle of the experts. This is important. So this, it's not like the judge is being asked to decide if the prosecution's experts are better than the defense experts. That's not how it works. So if the prosecution's experts are better than the defense's experts, well, the normal way is for them to battle it out in court and let the jury decide. So this is not that, is what Prosecutor Brennan is saying. He's saying, so this is not an example of a battle of experts best left to be resolved by the fact finder, which is the jury, but instead an attempt to infect the jury with an inadmissible opinion that is not premised on reliable digital forensics. Cellebrite has updated its software to prevent manipulation of data. So it's a loaded word there, saying that Rich Green manipulated that data, which might not be exactly fair, but worth putting in. He certainly manipulated his conclusions. Shortly before the defendant's first trial, Cellebrite created and introduced Physical Analyzer software version 10.2. Since the defendant's first trial, Cellebrite has added another version of updated software 7.67. The updated version removed the timestamp value for records sourced from the Safari's browser tab because further research shows that the timestamp is not a reliable source for a timestamp relating to the URL shown. So basically, in English, the Safari browser, there was a tab that was opened at 2:27, and that tab was used at 6:23 when Jen went back into the Safari browser. And so the program Cellebrite is confused about the timestamp, thinking that the search was made at 2:27, but it was actually just when the tab was opened or last used. James, someone also has been blocked, and I will say, James, I don't recall why, so I will take your message and I will look into it and unblock you after the show, and I'll apologize. What happened? It's probably me that did it. What happens is when you go to block someone, you like shade them on the chat, and then you have to right click. But sometimes the chat moves, and I've had this happen before where I accidentally block someone that I didn't mean to block. So when this happens to anybody here, if you don't believe you should have been blocked, just send me an email at leitskev@gmail.com. LEITSKEV @gmail.com. And I will fix it and apologize. And so I apologize to James, and I apologize to Karen McCormick. So, and we will get that straightened out. Okay. So Karen is going to log in under a different name. So she's going to be incognito. It'll probably be something that looks the same, though, knowing Karen. So you'll know it's her. All right. So where were we? All right. So the basis for Green's contested opinions has been all right. So the basis for Mr. Green's contested opinions has been refuted not only by the Commonwealth's independent experts, but by Celebrate itself, who has removed the type of timestamp relied on by Mr. Green from Celebrate's decoding engine. Just checking again. Sometimes these messages might be important, so I check. Okay, so James, again, I apologize. So I wish if this was the kind of thing where I was on with someone else, I could take a moment and do that now, but it's kind of hard to do it while I'm talking. So I apologize, but we'll get to it. All right. Further, when Jen McCabe's cell phone extraction is analyzed in the newest version of Celebrate, the 2:27 a.m. last visited timestamp no longer appears on the extraction report. So it didn't appear on the report, the version that was used by Trooper Garino. And then in a version that came out a year later that Rich Green used, it did appear. And then now it doesn't appear. It's been adjusted. And that's the nature of the beast with these programs. They have to be adjusted. And that's the danger of this data. You can have data. We saw this with David Yannetti doing this to Allie McCabe's data, which he tried to imply that she was taking multiple 18-mile trips all within an impossible time frame, going back and forth to the high school, which is presumably much closer than 18 miles, probably less than a mile. But trying to create this impression of all these nefarious trips going on. To me, it's unconscionable. But this is the world we live in now, that we have to worry about defense teams abusing this data. All right, so rather, the time shown represents the status of the browser tab and digital forensic artifacts pertaining to web history. And Apple Mobile Safari again confirmed that the How Long to Die in the Cold search occurred at approximately 6:24 a.m. Likewise, there was no evidence that the Google searches were ever deleted. There was no evidence that the Google searches were ever deleted. Oh, and so actually, you know what? Just to address Karen and James, what I can do is when I'm watching the Rich Green testimony, when we're all watching it in a few minutes, I will be able to hopefully find your names on the block list. All right. Even though Mr. Green's claims are wrong, the defendant herself has engaged in promoting this false narrative. In a June 20th, 2023 interview with Gretchen Voss, so they have access to this now, the defendant advanced this baseless claim. First court appearance, Karen, this is Karen. First court appearance after we revealed Jen McCabe. And then Karen, when she was interviewed by Gretchen, was with all three of her lawyers. So Yannetti, Jackson, and Little. So Little said Googled, and Yannetti said, yeah. And then Karen said, and it happened at the same time as the basketball search, which also wasn't in the report, nor was the How Long to Die at 6:23 that she admitted to. There were no Google activity in the Celebrate report that was handed over to us as gospel. So I don't really remember that. We'll have to go back. Maybe it'll come out in the Rich Green testimony, but it would seem odd to me that Trooper Garino didn't even catch the Hockomock basketball search, but I don't know. Maybe it's true. Inadmissible evidence should always be excluded. Allowing debunked claims to reach the jury would necessarily risk misleading the jury and creating prejudice to the Commonwealth. And the case they cited They quote from, the role of expert testimony is to assist jurors in interpreting evidence that lies outside their common experience. Mr. Green's factually wrong opinions would not assist jurors and would instead risk confusing jurors. So we'll look briefly at the case law here, and then I'm sure we'll get to a conclusion. My comment here, though, would be this. Again, just a bartender. But based on what he has said here so far, I think it's very unlikely that Mr. Green will be excluded. However, that was not the purpose of this motion. The purpose of this motion is just to get the Dauber hearing. So Hank Brennan isn't going to show his hand now. He's not going to show what he's going to use in that Dauber hearing to try to eviscerate Rich Green. All he needs to do is get enough here to get that Dauber hearing. So based on what we're seeing here, I don't think there's anywhere near enough to get Rich Green disqualified. But I think we're going to see if this Dauber hearing is granted, and I'm sure it will be, you're going to see a lot more from Hank. He's going to have, or Lally. I don't know. I mean, Lally has really become an expert in this wall file stuff, so it could be Lally even. All right, so this is case law. An expert witness is not permitted to testify to matters beyond an area of expertise or competence. So Rich Green is going to have to prove that he's competent. The prosecution is saying that he's not qualified to render an opinion, claiming that Jen McCabe's phone Googled how long to die in the cold anytime prior to 6/23, or any claim that Jen McCabe's phone incurred user deletions of any data. So this is a little, this could be better written. I have to be honest. I don't think this was written by McLaughlin. Obviously these guys are very busy. But in the opening paragraph, they're only talking about deletions of Google searches. But here, now they're again talking about user deletions of any data, which is different. A Dauber Lanigan hearing is necessary to assess whether the defendant may call Mr. Green to testify. It is the defendant's burden to establish that Mr. Green's testimony will assist the trier of fact to understand the evidence or to determine a fact in the issue. And that methodology or theory underlying the expert testimony is sufficiently reliable to be presented for the jury's consideration. Another case, the proponent must establish a sufficient foundation for a judge to determine whether the expert's opinion satisfies gatekeeper reliability. Clearly, the methodology or theory underlying Mr. Green's testimony is not sufficiently reliable to be presented for the jury's consideration. A jury should not be permitted to consider baseless claims. The defense will not be able to meet the Dauber Lanigan standard required. Conclusion. For the foregoing reasons, the Commonwealth respectfully requests the court to order a Lanigan hearing or exclude Mr. Green's opinions relative to the two contested claims. All right, so that's it. I would like to see more case law on that. So they have to show that this wasn't just a disagreement between experts. The state has to show here that, again, there's going to be specific words that are applied, but I'm just going to use my own, that Rich Green's analysis is reasonable. So I don't know. We'll see. So let's, before we go to the Rich Green, let's go to the caution. I'm going to go to a Melanie clip. And I haven't seen it before either. I don't even know how long they are, so we'll see how they go.
Going back to the document, the Commonwealth's expert, Ian Whiffen, is a Cellebrite senior digital intelligence expert and an expert in digital forensics. Okay, apparently he still works there. We had questions about whether he still worked there because he did launch his own app that his testimony in the first trial was like a very long infomercial for that app of his. So I guess he's still working for Cellebrite. And then pay attention here to footnote number 1. which says Celebrite is the leading forensic data extraction software tool that provides forensic examiners the ability to access and analyze data stored within a digital device. The Celebrite software allows an examiner to parse layers of data through different methods of extraction and analysis. So here they are telling you in footnote number 1, the Commonwealth, Celebrite is the gold standard, except for when Celebrite is applied to any of the Alberts or McCabe's phones or Allie McCabe's, and then it's not accurate.
That's just stupid. I mean, it's, again, trying to apply understanding to things. So, for instance, no one is saying, we didn't discuss this here, but another type of data would be the Apple Health data. No one is saying that the Apple Health program is lousy. You have to look in any situation when you have conflicting evidence, what is the better evidence? So when you have evidence, for instance, with the Apple Health data that says that John went inside the house, went up and down 3 flights of stairs, and walked, 116 steps, I believe. That's evidence, okay? It's not that evidence is inadmissible or on its own necessarily wrong. Then you look at the other evidence, which is the GPS, and also the Waze and other evidence that shows that John could not have gone in the house. So GPS is a location app that's designed as a location app. A health app is designed to help you exercise, and it's trying to interpret what you're doing, which could be very complicated. So the health app is excellent, but it's not easy to interpret motions and the other variety of inputs that come in the data. So it's not a matter of, no one is attacking Apple Health app. This is something that the FKR people do this all the time. So a perfect example is what I use in what I call the bulletproof correlation is that the way the vehicle data shows that Karen did this 8 minutes and 8 seconds after she did the 3-point turn on Cedar Crest, which is shown on John's Waze data, that she put the car in reverse and struck a smaller object behind her. That happens to be just a few seconds before the Apple Health app shows that John's phone didn't move. And so people on the FKR will say, well, why do you suddenly believe the health app now? Because the health app in that situation is not interpreting what you're doing. It's just saying that it's getting data that you're moving. There's nothing to interpret. So this is why you can't just, it's so simple that I don't know how this person got to be a lawyer. To sit there and say, well, why do you believe Celebrate here and not here? Why do you believe it there and not somewhere else, Melanie? What we try to do is apply understanding to analyze the data. That's what the experts have to do. That's what a real expert will do, and look at all the other information around it to try to determine what happened. So, I mean, this is, I don't know where they found this person. All right, here's the next
Hank Brennan has just told every prisoner who's locked up. I don't know if you guys get YouTube in prison, but if you're locked up based on the timestamp on a Google search and the Celebrate extraction, you now have a get out of jail free card, pretty much, because it's not accurate. Because he's telling you guys that Celebrate was wrong all along until after Karen Reed's first trial, when they now all of a sudden have removed that timestamp. Everyone locked up because of this needs to go free. That's right, Holly Ann Crow.
Oh man, it's like watching this stupid there was a really great commercial put out by Apple Computer in the 80s. So most of you guys don't remember it, but it was a take on the Orwell book 1984, and these guys are just sitting in the audience just nodding. They're just brain dead, and I picture the Free Karen Reed crowd just watching Melanie going, it's like oxygen isn't reaching. That is not the state is not saying that no timestamp should ever be accepted in Celebrate. No, it's a matter of getting all of the data and doing the best you can to interpret this stuff and making the program more and more accurate and looking for glitches. There's always going to be glitches like that. Oh my God. It's does she believe this stuff? I don't know when she says it. That's what I don't know. Some of these people, they're so one-sided that you wonder if it's not real. Like they don't really believe what they're saying. They're just kind of saying it for popularity, clicks and views, donations, to be loved by Karen. I don't know, whatever. So, all right, let's go to the Rich Green. And again, I've put this at 1.5 speed, but you can still understand them very well. I watched it like this before. Leave the comments in chat because some of you guys might recognize yourself, like Maui and Jules in the chat here. I think this is from my channel, my coverage. It says Law and Crime there, but I was using that feed, so it's from my channel's coverage of this during the trial. And away we go to Rich Green. Oh, volume is down.
With numerous public defenders. We've worked with a federal public defender. We've worked with law enforcement. So quite a variety of clientele.
Civil cases?
Yeah, civil and criminal. I would put it about 60% criminals, 40% civil.
Okay. And on the criminal side, you've done both law enforcement and defense, correct?
Yeah, most of the law enforcement ones, though, have been more geared towards civil. It's when they had perhaps they were party to a suit, and it was just improper for them to use their own experts. So that's where we've provided assistance.
Now, how long have you been involved in the field of data forensics?
Sure. Well, my first case and testimony was 28 years ago. I'm not even sure we called it data forensics back then, but that was 28 years ago. And then about 16 years ago, started the company United States Forensics, and been full-time in the industry since that point.
All right. Now, you mentioned that you'd actually testified for the first time 28 years ago. That would have been 1996, if my math is correct?
That's correct.
You qualified as an expert witness at that time?
Yes, sir.
In order to have been qualified as an expert witness, you must have had experience before that?
Yeah, it was specifically in computers. We didn't do much with cell phones back then. By about a decade or so in computer IT, networking. We actually built a line of computers, a lot of repairs. So I was pretty deep into the computer IT world at that point.
Okay. And you say you formed your company in 2006?
Correct.
And you work full-time, part-time? What's your schedule?
It's been full-time ever since.
Would you describe for the jury, please, your educational background, your training, certifications, etc.?
Why don't we break it down into smaller segments?
Sure.
Okay.
First, with regard to the training that you've received.
Sure. So that would have to do with Associates of Digital Forensics.
Well, that would more be your education, right? You received an associate's degree in digital forensics?
Correct.
Okay, so why don't we start with education since you did?
Okay. Well, that was part of the work and more or less the formal training to get that degree. The certifications, which again, this all kind of goes hand in hand, but the certification training would be the CCE, which is certified computer examiner from the International Association of Criminal Investigation Specialists. I also have a certification as a computer crime related investigator, cybersecurity, as well as computer first responder. The training aspects over the last 18 years on really a daily basis, when I've worked, I've participated in listservs, done research into the newest developments in the computer forensics, and really on usually a weekly basis, we'll target some training seminar. I found in this business, even if you took like 6 months off, you would start to get behind in this business. It changes that rapidly, and you really need to do continual training.
Okay, and again, your voice trailed off a little bit at the end, so
I'm sorry.
I'm sorry to keep reminding you, but I just want to make sure everybody hears. With regard to the amount, your caseload at USA Forensics, can you give the jury some idea of how many cases you handle on a yearly basis or have handled historically?
Yeah, we average, I'd say between 100 and 120 cases a year. We probably get inquiries to about 3 times that amount.
Okay. And have you testified as an expert witness in the area of computer forensics since that 1996 first appearance?
Yeah, that's right, about 2 dozen times in various state and federal courts.
Whatever he's done, none of it's on his website. None of it, for whatever reason. So if you're that busy and you're doing all those cases, I don't understand why none of that is on his website. It's really strange to me, but maybe let's speed this up yet some more. Hopefully, I don't know if 2 times is too fast. Let's try to speed it up to 2 times, and then we'll slow it down when it gets to something that's more relevant, so we can plow through this.
State courts, is that state court, federal court, both? Now, direct your attention to September of 2022. Were you contacted by somebody to come involved in this matter?
Yes, sir.
Who that was?
I believe it was Ms. Oil.
So I want to point out here too, so he was first contacted in September of 2022. This is a month after Karen and her team went into the office of then First Assistant U.S. Attorney Josh Levy, now U.S. Attorney Josh Levy, who personally decided to launch a pretty massive investigation into this case. So whatever he launched it on, it had nothing to do with any of this data that Rich Green is going to talk about.
What were you asked to do?
Whether it's 3 cell phones related to this case and to provide relevance with the data on those phones as related to the incident on January 29th, 2022.
Okay, and were you aware of the owners of those 3 phones?
Certainly. It was Karen Reed, John O'Keefe, and Jennifer McCabe.
Now, I'd like to ask you first, if I can, about John O'Keefe's phone. How did you receive the data from that phone, if you remember?
Yeah, we received what's called an image file, and that's a forensic term that we use. Essentially, it's a copy of the data that's encapsulated into a single file. In this case, it was a zip file.
Did you examine that data?
I did.
What were your goals during your examination of John O'Keefe's phone? What were you looking for?
Well, initially, what was the location data. We wanted to get an idea of when he had arrived and anything else that we could tell from that as far as location.
And when you say when he arrived, do you remember the location that you were asked to learn when you arrived?
34th Fairview.
In Canton?
Yes, sir.
Were you able to determine, as a result of your examination, approximately when his phone arrived at 34th Fairview Road, according to the location data?
Yes, sir.
And how did you do it?
Sure. Well, I say we, so that's proverbial we. I extracted the location cache data, which is stored in on your phone, and it's in the certain location. We exported that out, and then we use a tool called CellHawk, and we import it in there, so we can take literally thousands of data points and automate that process to specific GPS locations, and just as importantly, the range of accuracy that location is reporting.
Okay. So according to the process that you underwent, what time did the location data indicate that John O'Keefe's phone arrived at 34th Fairview on January 29th, 2022?
So the first one right to the driveway was at 12:24 and 28 seconds.
12:24 and 28 seconds.
Correct.
Now, if I asked you to...
Now, keep in mind, he just said that the cell phone arrived at 12:24 and 28 seconds. That's when it arrived near the driveway. But when he says John was going up and down stairs, was before that, was 2 minutes before that. So by his own testimony, it doesn't make sense, but we'll see if he can try to recover it.
Filter John O'Keefe's location data within an accuracy of 3 feet using CellHawk. Could you try to do that?
Yes, sir.
In fact, did you try to do it?
I did.
When?
Last night.
Who asked you to do that?
You did, sir.
All right. Again, this is a perfect example of the games that these attorneys play. So the night before he's going to testify, David Yannetti asked this guy to look at, let's go replay that, about the accuracy within 3 feet, which is, you're not going to find, that's not, GPS is not accurate within 3 feet. It's accurate within 3 meters, which is 15 feet.
Data indicate that John O'Keefe's phone arrived at 34th Fairview on January 29th, 2022.
So the first one right to the driveway was at 12:24 and 28 seconds.
12:24 and 28 seconds.
Correct.
Now, if I asked you to filter John O'Keefe's location data within an accuracy of 3 feet using CellHawk, could you try to do that?
Yes, sir.
In fact, did you try to do it?
I did.
When?
Last night.
Who asked you to do that?
You did, sir.
Again, 3 feet. You're asking.
Yes.
You're asking a question. That's restrictive. That is intentionally so restrictive that it's going to throw the testimony off, because there are not going to be any data points that are accurate on GPS within 3 feet, because it's just not that accurate. It's accurate within 3 meters. And that's actually really accurate. If you look it up, GPS is generally accurate within 3 to 5 meters. So that's why Trooper Greeno said 15 feet, not 3 feet.
So I placed that document before you. Could you familiarize yourself with that and look up at me when you're done?
All right.
Recognize that?
I do.
What is it?
So this is a screenshot from the CellHawk program. It has a kind of a central box here that says database settings, and this is where we apply a certain filter.
And what filter did you apply?
This was for the accuracy of less than or equal to 3 feet.
With regard to...
Again, you have to understand how shady this is. He applied a filter. So he's only going to get results of GPS points that are accurate within 2 or 3 feet, which is probably going to be 0. That's because it's not that accurate. That's why Yannetti deliberately chose that number.
What?
John O'Keefe's location data.
Is that an exact is the data on that document exactly what you received when you used the CellHawk program to filter the data?
Yes, sir.
I would offer that, Your Honor.
No objection.
No objection. Sir.
Oh, I'm sorry. I thought you said objection.
So you need to give it to Madam Court Reporter?
I'm all flustered. Sorry.
You're all flustered because you're being a schmuck, Eddie. So this, you could look on that map there, and I don't think they bring it up here, but it's going to go to the jury. And the map shows 0 data points because they had it filter, like I said, to what GPS points were accurate enough within 2 to 3 feet. And the answer is none of them will be. But they already know. Why? So why would Yannetti ask this now? Because he's already heard Trooper Guarino testify a couple of days before that the accuracy was in 3 to 5 feet. I'm sorry, 3 to 5 meters or 15 feet. So deceptive.
And if the witness could have that again.
Thank you.
With permission, I'd like to publish that one. Okay, so, Mr. Green, what are we looking at?
Okay, so that is the screenshot from the CellHawk.
All right, so they do show it.
And what can you tell us about what you learned from that exhibit?
Well, yeah, I'll just use the pointer. It might help. You can see up in this part here, where this is where we apply the filter for 3 feet or less. That'd be the accuracy. And then it actually returns 0 results, meaning all of the data within there had an accuracy rating higher than that 3 foot. It could be 5 meters or 10 meters, but none of it was granular enough at a 3 foot or less accuracy level.
You can stop right now, any one of us, and go on to Copilot on Bing, the search engine, which is a version of ChatGPT. And you can ask what the standard margin of error is or accuracy for GPS. And it'll tell you 3 to 5 meters, which David Yannetti knows, which Rich Green knows. So this was what goes to credibility. They're trying to suggest that GPS was not accurate by giving it impossible parameters here. And so this is why you come up with something like this. Why do they do this? Because they have to do this, because the GPS shows that John's phone never went in the house. So they have to play a game like this. But this is just a lawyer's trick. And it'll fool pink shirts. I don't know why. I mean, honestly, I just don't really, I don't understand it. I mean, even somebody with 6th grade education, if you explain this to them, they're like, oh, yeah. Why would this fool people? I don't even understand it.
And if you had inputted accuracy within, say, 500, what would you find?
Yeah, you would see then a large number of circles, each circle representing the meters that the accuracy would be related to. What's really important to understand, though, is you don't want to look at just the middle of the circle. That accuracy indicates it could be anywhere in the circle. So if you saw one and it encompassed 2 or 3 houses, you could only draw that inference.
So so somebody just messaged me that you guys don't like the video too fast, but we don't want to be here for 3 hours, so that's why I'm playing it a little bit faster. Is that okay with you guys? Does that make sense? So yes, Tom, I'm at 150. So I just turned it down to 125, but otherwise we're going to be here all night. So let me try it at 125 and see if you guys
of somewhere in that circle. So it's kind of like how the hurricane, they say don't just look at the cone, right? Because it could be different than that. Also, the accuracy, this is Apple's best guess at what the accuracy is. So it could actually be different than that. It's Apple is using a number of services, and they're giving back the best estimation that they can for the accuracy.
Oh, so we've talked about the location.
So let me expand on this a little bit, though. Sorry to interrupt. So when you get the GPS signal, so your phone has a chip in it that's designed for one purpose, is to get GPS signal. It only receives information. It doesn't transmit it. That's the raw GPS. And the accuracy or the margin of error is going to be based on the strength of the signal. And that strength of signal is measured always, so continuously, so from second to second. But in addition to that, the Apple location data uses a little bit more. So so the more data you can get, the better. So they will try to expand on that by getting information from other sources, most notably from a cell tower. But that only serves to make it more accurate, not less. So, but you're always going to know from the raw GPS data what the margin of error is. And Trooper Garino explained that perfectly well.
Cache data and where it put John O'Keefe's phone in terms of arriving at 34 Fairview, but was there also Apple Health data on John O'Keefe's phone during that time?
Certainly, yes.
Is Apple Health data generally accepted within the forensic science community as being reliable?
Well, the Apple Health data comes from something called HealthKit, but it's integral to the iOS system. So anyone that has an iPhone probably seen Apple Health data, and it's known to have extremely valuable data that the forensic tools work with and present to us. The degree of accuracy, it depends on the type of data that's being pulled out on the artifacts. For example, steps are known to have an accuracy of around 98% on the actual steps occurring.
So if the Apple Health data returns, for instance, steps 20.
We can expand on what he said here. Yes, it's 98% accurate on the number of steps you take if you are actually walking. All right. So if you walk from here to downtown, it's going to be 98% accurate as to how many steps you take. But if you're skiing from here to downtown or roller skating, it's not going to know that. And this is where so this is the issue here, is not how many steps John walked from the waterfall to the car. In fact, somebody pointed out to me, they calculated this, and they showed me that the data, and if it's accurate, that in the time when John was supposedly walking these steps at 12:22 and something seconds, his stride, according to that data, was 3.5 or 3.6 feet. And the average male stride is 2.5 feet. And you don't see over 3 feet unless somebody's like running in a track meet. So it's an and when you look, and actually they can look at John's stride when he is certain to be walking. So for instance, when he's walking downtown, it's 2.5 feet, just like every other man. But in that spot when we know that they were actually driving on Cedar Crest, the stride is measured at 3.5 feet. So that's just another sign that data is misinterpreting what's going on.
20 steps within a certain time period. 98% of the time, that was going to be right?
That's what studies have shown.
All right. May I approach the witness, Your Honor?
Yes.
Do you want this back? Okay.
Mr. Green, I've placed another document for you. Do you recognize what that is?
Yes, I do. This is this lists out Apple Health data for that was from John O'Keefe's phone on January 29th, 2022.
All right. That came from the data that you received, the image file of John O'Keefe's phone, correct?
That is correct.
I would offer that, Your Honor.
So,
No objection. And with the court's permission, may I publish that, Your Honor?
okay.
Specifically, I'd like to start with page 2, record 2. Hey, Mr. Green, are you wearing the right glasses to be able to see the scene?
Yeah, I probably need bifocals here. I keep switching glasses, but
are you able to read what is on the screen? Or if it's easier, you can look on your document in front of you. It's page 2, record 2.
yeah, I think I'm going to have to do that. I can probably still see good enough to do the laser one. I'm sorry, which record is this you're looking at?
Page 2, record number 2.
Okay, yes, I have that in front of me.
Okay. What does record number 2 show on page 2 of John's Apple Health data? Sure.
So this is the number of meters. It's listed as 87.74, and the time is listed between 12:21 and 10 seconds. And there's a milliseconds after that, but I'll just round it off to the second if you don't mind. So 12:21 and 10 seconds to 12:24 and 22 seconds.
Okay. And you said that it showed 87 meters traveled during that time period?
Correct.
And with regard to that same time period, 12:21 and 10 seconds and 12:24 and 22 seconds, please turn to page 5. And Mr. Bates, if you would zoom in on record number 2.
I have that.
Okay. What does record number 2 reflect?
Again, it's the same time period, and the steps taken is recorded as 80 steps.
Okay, and you said it's the same time period, so again, 12/21/10 to 12/24/22, correct?
Correct.
All right, now I'd like to direct your attention to page 4.
So 12/21/10 to 12. What is it? What did he say? It was 12/24/22. Again, he already testified just minutes before that John didn't arrive until 12/24/28 seconds. So by his own data here, by his own testimony, John is driving there and taking those steps.
4, record number 1. Thanks, Mr. Bates. What's that? When you're ready, Mr. Green, if you could tell the jury what that reflects.
Sure. So this indicates 3 sets of floors. That represents elevation change. So it doesn't indicate to us up or down, but 3 steps. And the time period for that is 12/22/14 to 12/24/37.
Okay, did you say 12/21/14 to 12/22? I'm sorry, 12/24/37.
Yeah, 12/22/14 to 12/47/37.
So again, the end of the time 12/22/14 to 12/24/37, when by his own data he's going to say that John arrived there at 12/24/28. So by his own data, it's impossible. And we know that during this period here, in that 2-minute period while they were driving, the elevation of the roads changed. The elevation between the 2 points is about 30 feet, which is 3 stories. But in addition to that, I actually figured out something that happens once in a while, that if your car suddenly warms up on the inside, if it warms up, say from when they left the waterfall, the inside of the car would have been about 18 degrees, 20 degrees. And it takes about 7-8 minutes for the engine to warm up to where you start pumping out that heat, on a really cold day. And it finally gets there and you're like, boom, and you crank it. That would have been exactly right around on, I think, Oakdale Street, I think is the name of it, which is when this alleged changing out stair climbing began. And that's right around when they would have cranked the heat, and the temperature would have gone up to maybe 75 degrees inside that car. And I used a program to calculate that. And the change in the health app, the phone uses barometric pressure in order to determine elevation changes. It's not using GPS. It's not able to do that for something like that. So the change in barometric pressure going from 18 degrees to 75 also just happens to coincidentally be similar to 3 flights of stairs.
Nice. And with regard to all of this data, the 80 steps and the 3 flights of stairs that you mentioned, is it possible to pinpoint where within the time frame that's given those steps or flights of stairs were ascended or descended?
No, the most granular we can get is the time period, and it doesn't signify as any more likely at the beginning of the time period than at the end of the time period than at some time in the middle. And if you think logically, like distance traveled, that doesn't happen at a split moment. It happens over a period of time. So time is a factor in that equation, and this is how the Apple records that data. You got to look at the time overall.
Okay, so you don't know if the steps are bunched up toward the beginning or toward the end or more evenly spread out?
No, I would not be able to tell you that.
Now we've discussed the Apple Health data. I want to go back for a second to talk about the location data on the iPhone. Does that data that you've already talked about in terms of the arrival time that it gave for John O'Keefe's phone at 34 Fairview, does that arrival time fall within or outside the range of 12:21 and 10 seconds, or 12:21 and 10 seconds and 12:24 and 37 seconds?
Well, that certainly indicates an overlap, but the health data is ending after the arrival. And
now, I'd like to discuss with you the concept of clocks.
Yeah, there's an overlap, but it's only about 8 seconds. So in that 8 seconds, that would have to be when he got out of the car, walked 80 steps, and then went up and down 3 flights and stairs, all with his GPS showing he never went near the house.
Used by apps on an iPhone.
Sure,
Are you aware of the 3 different clocks that are used by iPhone apps?
I am.
What are they?
We have you have 3 separate internal clocks. You have a monotonic clock, a baseband clock, and a wall clock.
Okay, and is the wall clock also called a display clock?
Yeah, that would be also a common name for that.
And what is the significance of the existence of 3 clocks regarding different times that may show up within these records?
Sure. Well, app developers can access Apple program library, and they can call upon any of the clocks to use within their apps.
Okay. Now, in your investigation and examination of this case, did you find examples on this phone of different clocks being used?
So in this particular case, I had reprocessed the data with the newest version of the Axiom forensic program. It's similar to Cellbrite. There are competitors to Cellbrite, and we use both programs. And this newest version had a feature in there where you can filter for the Waze application. And again, just following up and seeing how this functioned, we filtered for the Waze application. And for the first time, we saw this monotonic timestamp being related to the Waze application.
Okay. I want to show you Exhibit 640, if I may approach, Your Honor. I've placed Exhibit 640 before you, sir. Do you recognize what that is?
Yes, sir.
What is it?
So this is a screenshot from the Magnet Action program I was referring to. It's the 8.1, actually it looks like 4287, but
Keep your voice up, sir.
I'm sorry. Yeah. So it's the newest version of the program, and we have it filtered for the Waze app, and it's giving us the timestamps associated with it.
With the court's permission, may I publish that?
There we go.
And first of all, that might be probably too small. I can't read it.
Okay, thank you. I'll go off of this one.
There we go. With regard to what we are looking at there on that part of the screen, what are we looking at, Mr. Green?
Okay, so this is listing details of this particular artifact, and you can see that this is bundled. The com.waze.iPhone, that is a standard bundle type name where it always starts with com. And then the application reference.
And what does that mean? It's highlighted on the screen, com.waze.iPhone. What does that mean that we're in right now?
Yeah, well, this is an artifact specifically related to the Waze program.
Waze app.
Yes, sir.
All right, go on.
Okay, and we can see here our entry for the monotonic time, the baseband time, and the display time.
And what did you notice about the relationship of the 3 of those?
Certainly. Well, most noticeable about this, the monotonic is running a little over 3 minutes ahead of the display. So I think it's 3 minutes and 1 second, give or take a little. So, in a lot of cases, 3 minutes may not seem like much, but in this case, this struck me as important to objection. Hold strike.
Sustain. I'm willing to strike that. Next question.
Okay, I apologize.
You can hand that back to Madam Court Reporter.
Certainly. Thank
And
you.
I'd like to go back to the Apple Health data, Mr. Green, if you can put that back up. And this was to be page 2, record number 3. And you don't still have that in front of you, do you?
Actually, I do.
You do.
I do.
Page 2, record number 3, sir.
Yes, sir.
What does that show?
All right. Okay, so this is another entry from John O'Keefe's cell phone data, and this records 25.46 meters occurring between 12:31:56 and 12:32:16.
Okay. And directing your attention to page 5, record number 3, you can tell the jury what that shows. And if we can have that displayed as well, Mr. Vince.
Certainly. So this is directly related to the distance, and this is recording 36 steps, and it's the same time period, 12:31:56 to 12:32:16.
Okay. So we have 36 steps being taken according to Apple Health data on John O'Keefe's phone for a time period that ends at 12:32:16.
Objection.
Sustained. Ask it differently, Mr. Green.
With regard to those 36 steps, do we know where within that time frame they were taken?
Sure. Let me reread that here. We January 29th, 2022, 12:31:56 a.m. It's actually 12:31:56.109 a.m. and 12:32:16.507 a.m.
Okay. All right. So now I'd like to switch, if we can, to Jennifer McCabe's phone and your analysis of that. During the course of your examination, when you reviewed data from her phone, did you find a particular artifact of interest?
Yes, I did.
What did you find?
We found a Google search that happened. First of all, the search was "How long to die in cold," and it happened at or before 2:27 a.m.
All right. Where was that search found?
Sure. So that the artifact on that was called a Safari Suspended Tabs artifact, and there's a database associated with that called the Browser DB database, and in a company file, which is by the same name but ends in WAL, which stands for Write Ahead Log. And the write ahead log is where the data first gets written to, and then that certain points, that data then gets committed and written to the main database.
All right, so that, if I'm correct, that browserstate.db/wall file, that's a temporary file, right?
It's temporary by nature, but it's not. It's integral. It's part of the way the SQLite functions. So it's not like a throwaway file. It's part of the way the whole system works.
And is it helpful to you when evaluating artifacts?
Certainly, yeah. Just by nature of it, we'll find a lot of the newest artifacts in that wall file.
Now, how do you determine the timing in terms of the timestamp on the browserstate.db wall file?
Sure. So the wall file has different rows and columns. You can kind of think of it as an Excel spreadsheet. And in this one particular column, had it was a time column. That'd be the nature of the data going into it. And this the heading on this particular one was last viewed time.
Okay. Regarding that Google search for HOS long, and I say HOS, HOS long, the
Correct.
and cold, found in the browserstate.db wall file, what was the date and time for that artifact?
Sure. So that's recorded in what's called Apicola time, and it's actually the number of seconds since January 1st, 2001. So you end up with this large number, and that gets converted to present to us something that's human readable, and then you have to apply the offset for the local. So once you do all those calculations, that's where we get the January 29th, 2020.
All right. So if you guys want, it's almost at the end of the direct here, but so we already kind of know what he's going to say. So let's skip to the Lally part, which is a shorter questioning of it. But take my word for it. At no point does Yannetti ask him about Karen, anything about Karen's phone. Doesn't ask anything about the location data on Karen's phone. Nothing. He never asks it, never brings it up. So let's see where Lally is.
From the jury, please.
Yes, this is another report generated out of Cellbrite. It's based on Ms. McCabe's cell phone data, and this lists out the call log with after the 8:59:34.
What percentage of phone calls were found deleted on Jennifer McCabe's phone prior to 8:50 a.m. on January 29th?
So all right, I have to see you. Take this down for a minute, please. I have to see counsel.
You know, you always have to question, does this guy really not know, or is he just completely dishonest? You know, and you never really know. And this is a normal part of trials, unfortunately. No calls were deleted. They're just moving to other folders. I don't know why we got stuck with the cottage here. I mean, unless there was an interruption here, I don't know. Unless it was, but there obviously was some kind of an interruption here. So I guess it's possible that David Yannetti asked something about Karen's phone while we had this glitch, but it doesn't seem likely because he was.
Yes, sir, I understand that.
And have you had a chance to review those materials as well?
Yeah,
Yes, sir.
We missed the beginning of that because
disagree with what
of the
your opinion
glitch.
is in relation to those, sir.
I absolutely understand that, sir.
So is
Now, just as far as your qualifications and certifications go, I'm just having a certifications that you have. At what point were you, or what if any certifications do you have with reference to Cellbrite as a tool, as far as your use and interpretation of data from Cellbrite?
Certainly. So my certifications are much more broad. They have to do with a lot of the fundamentals and how we conduct the investigations and what tools we should know and when we need to know we need to do more work and such like that. Cellbrite, I do not have any specific Cellbrite certifications. They offer many of them. However, I have participated in, God, I can't even count, hundreds of their training events that they offer, both Cellbrite, Axiom, Belkasoft. They all provide the community with fantastic support as far as that. And although certainly a class can be very good, but you really need to stay up to speed. You've got to participate in the most recent understanding being put out there. Even in the changes of their tools will change from one version to another.
And so, to the point, as far as you have no certifications in regard to Cellbrite as a tool and how to use it, those kind of things.
That's correct, sir.
And in this specific instance, at any point, did you reach out to Cellbrite to go over sort of your findings or your opinions in relation to this search?
I did.
And who, if anyone, did you speak with from Cellbrite?
Yeah, as close as I can remember, I know it was Leo, and I believe it was Santos.
And do you know what part of Cellbrite they work in or what they do?
Well, he was in the technical support, and contacted him. He had informed me that they had elevated this up to some higher level technical support when they came back. His comments to me, if you want to hear them, was that this. Okay.
After his comments, but at some point,
I understand.
you talked to technical support, is that correct?
Absolutely.
And they indicated that they would refer you to actually Mr. Whitten's team?
No, sir, they did not.
So you weren't told that you were referred to Mr. Whiffen's team and you weren't contacted by anyone from Mr. Whiffen's team?
No, and I forget the exact date. A couple weeks ago, maybe a month ago, out of the blue, I got an email from Ms. Whiffen saying, and I can't. I don't want to misquote him, but certainly I got an email
I'm
from
not asking
him.
you about any specific conversation
Okay.
you had. What I'm asking, and I'm asking about a time period more back in 2022.
I'm sorry, I couldn't quite hear you.
Back in 2022, did you reach out to Cellbrite in relation to this search and your opinions related to it?
Yes, sir.
And at that point, was that the point that you spoke to someone from technical support?
Yes, sir.
And at that point, did someone from technical support actually refer you or tell you that they were referring you to Mr. Whiffen's team?
No, sir. I had absolutely no idea about that.
So no one from Mr. Whiffen's team reached out to you, and then you just never called them back. That didn't happen.
Not that I'm aware.
So we'll see about this. It sounds, see, Adam Lally can't come out if he knows that Whiffen reached out to him or somebody from his office reached out to him and that Rich Green just didn't take the call. In fact, if I seem to remember right, there was something about that. Did they have a pretrial hearing with Rich Green? I don't remember if they did or if they had any kind of a voir dire with Rich Green. I don't remember. But this suggests that somebody from Celebrite, from Ian Whiffen's office, did try to get in touch with Rich Green, and he just wasn't interested. But Adam Lally can't say that unless they bring in that person from Celebrite and that person testifies to that. Maybe so they may do that this time because it goes to his credibility if he's using this tool to produce this unusual result that doesn't make sense, and he has no interest in the senior data analyst who gets in touch with him from Celebrite.
Now, you were asked to look at a couple different phones, and I'm assuming by counsel for the defendant, correct?
Hey, can you say that once again? I'm sorry.
You were asked to look at 3 different phones is what the testimony was.
Here it is, guys.
And I'm assuming that was by some counsel for the defendant, correct? No one else asked you to look at these phones,
Oh,
correct?
correct. Yes, it was from the defense asked me to. Yes.
And so the phones that you were asked to look at were Mr. O'Keefe's phone, the defendant's phone, and Ms. McKay's phone, correct?
Correct.
Now, as far as Kerry Roberts' phone, when you were asked to look at that,
No.
and with respect to the defendant's phone, was there any GPS location information or data that you observed in her phone?
So we had an indication that location had been using, there was something called Apple Map tiles. And those probably, when you use the Apple Map app, that it, in order for it to work, it will create these little tiles or little pieces of pictures, and they get stitched together to give you the view that you see on your phone. Now, for that had to be working, we know location data had to be working. This particular location.
He doesn't say when it had to be working. He just says that location data had been working. So this is where you got to always parse their words because they're tricky. All right. He's not trying to tell the truth. Remember that. He's not going to lie. And he's not lying here. He's saying, oh, well, we found location data, but that's before she turned it off. Now, we already learned from Trooper Garino that she had turned off her location services. And this is common because, especially if you're taking a trip to Aruba or, someplace out of the country, because that location data is involves data charges. And so most of us at this point, the location data. So if you navigate through Waze, you have to turn on your location data. But for most of us, unless you're using YouTube a lot on your phone, even if you have a limited data storage, you're not going to use it up just on that. But if you use it a lot, you can. But if you go outside the country, it's different. The data can be very expensive.
Data, the location data cache is known to only be present on the phone for a couple weeks. Now, what I don't know, and Mr. Lally, if I'm going too far, just please stop me. What I don't know are what measures were taken to preserve that data, whether it was put in airplane mode.
Well, we do know because it was either Proctor or Buchanan testified that they put the phone in airplane mode, which would have turned off location data. And the defense did not dispute that.
Where the location services were turned off, whether it was put in a Faraday bag. And quite frankly, Mr. Lowry, I don't know if they did all that, if the location data would have remained or not. I've never tested that, but all indications, it would have had location data on the day that it it was seized because we received the Apple map tile. But when I got the full extraction, there was no location data there. Now, I did observe.
So there was no
Okay.
GPS location data on the defendant's phone, correct? From what you observed.
And again, if I'm, I did find deleted location data from April of 2022.
So this is the basis and the only basis for Melanie saying that Karen's location data was wiped. Now, if this means what Melanie and Karen are now trying to claim that it means, the big question is why didn't they point this out in the trial? Again, as I said earlier, this would have been the headline news. Karen's GPS data wiped by the police. Right? I mean, if you went in there and Karen's all of her phone messages were wiped, that would be a big deal, right? If John's GPS had been wiped, big deal, right? But the defense didn't come back and ask. They didn't do it. Let me look forward here to see if to make sure. Yeah, that this was it. I'll go into the next day's trial to make sure, but I don't believe that there was any other redirect of Rich Green. Let me just play another few seconds and then.
Now, with respect to the defendant's phone, did you also find deleted web history data from the afternoon of January 29th, 2022?
No, I'm sorry, I didn't observe that.
Didn't observe it, or didn't look for it?
You know, I really don't have a recollection if I specifically looked for deleted data. I don't believe I did. I don't know.
Of course he didn't look for it because he knows who he's been hired by. He's hired to help the defendants. That's it. He's not going to look for anything that's going to incriminate her. All right. So let me just make sure that, because I want to check this to make sure, because it's possible the day just ended and Rich Green did come on. Let's see if he did. Want to see? No, he didn't. No, it went right. So that was it. All right. So that was actually it for Rich Green. Afterwards, you would think, right, that the defense would have jumped all over that. And they get another chance to come back on redirect and say, wait a minute, Rich Green, are you telling us that location data was wiped? But they didn't even go. They didn't even go to, take up the opportunity to ask him any more questions. That was it. A couple minutes after this, Rich Green ended his testimony, and he was never called back up. So this would have been headline news. This would have been huge news. But now it's something that they're only talking about now. I'm gonna, is it Melanie's belief that neither Jackson, nor Yannetti, nor Little, nor Karen herself, nor anybody else in her legions and legions of fans noticed that Rich Green claimed that the location data was wiped? Nobody noticed that? And that's why they didn't bring it up before? No, because they know it's bullshit. That's why they didn't want to bring it up. It's so anyways. All right, so that's it for the documents, and I get to say thank you to people. So Rose Water, thank you very much. She says, Happy New Year, Kevin. You are beautiful, and we love you. As long as I keep my shirt on, right? Thank you, Rose. And Gene Doctors said, Kevin, I think it's too fast. Sorry, I couldn't see those while I was screening it, but I didn't want to spend all night on it. But and then she followed it up. Hopefully she followed it up to say it's okay now. But I don't know. Rose said, we have a surprise coming soon. Do tell, Rose. Do tell. Who has a surprise coming? Is Rose speaking for the defense or the prosecution? What do you got, Rose? What's the surprise? Or what side are you on here? I'm not familiar with your commentary. The dude abides says they're getting angry because the truth you speak contradicts the lies they live. Yeah, they aren't interested in the truth. Melanie's definitely not. Rose, don't leave me hanging. What do you got here? What's the big surprise coming? Thank you, Judy. Rose is leaving us hanging. And I don't even know what side Rose is on. Is she saying the defense has something big surprise coming out, or the prosecution? Is she going to give us a clue? Let's see. Nima over in Sweden had a question, but my chat screen is moving too fast. So I have to, let's see. All right. Nima says, Kevin, have I misunderstood that it's not Green's entire testimony that they want removed? I thought it was just this one against Jen McCabe. No, I think based on the egregious mistakes that they claim he's making, they want him completely removed. Moopert Wallstead, that's another new name to me, but thank you very much. I appreciate it. Wow, that's very, very generous and undeserved on my part for sure, but thank you very much. I appreciate it. Turtle out there in Iowa, I think, if I remember right. Kevin, do you know anything about the 6-page anonymous letter? No, I have no idea what's in there. I did see there's in the discovery has been entered a 6-page anonymous letter. Says it's addressed to McLaughlin, the assistant attorney. I have no idea what that is. Could be, maybe, I'd just be speculating. Something from a juror, because the jurors always wanted to remain anonymous, but I don't know. I have no idea. Again, thank you, Moop. I appreciate it. Mooper. Chick from the Bricks, same question. Anything on the 6-page letter? No, I got nothing on it. I got nothing. A show about nothing. Does Turtle Boy say that Karen was chosen by God to be in this position? Maybe, right? If you believe in God, maybe it's to highlight all this insanity. But let's see. Hot Mess Mom says, I read that the chip-off showed her being back there for 7 minutes. I think it was before going to Jen's, not for sure, but I cannot wait to see those official results. I don't know anything specific like that. So, and I just try to really deduce from what Karen is saying and through her minions. And through her minions, they're clearly worried about the GPS data. That's why Melanie's going into that. Yeah, so Melanie said it was wiped in April 2022, but that's not what Rich Green said. I just played it there. What he said was data from April was deleted. Okay, and again, we've seen Rich Green has all kinds of confusions about deletions. But I also know that they didn't have access to Karen's phone until August because they couldn't crack the code. They plug it into a machine, I forget what it's called, that cycles through all the passwords, and it wasn't until mid-August that they got through to that. So, yes, I have read the book, and the book is outstanding. Actually, so Espink sent me another video from Melanie, so I'll throw it up if you want.
The Commonwealth asserts that Mr. Green is not qualified to render an opinion claiming, 1, Jennifer McCabe's phone Googled how long T die in sicked or how long to die in cold at any time prior to 6:23 a.m. on January 29th of 2022. And number 2, any claim that Jennifer McCabe's phone incurred user deletions of any data. See here, it says any data. But in the first paragraph, they just were referring to Google searches. But now, any data, because remember how many phone calls she deleted?
So she did notice the same thing that I noticed. So that's good.
Allegedly. Text messages, screenshots, and Google searches. So which is it? A Daubert Lanigan hearing is necessary to assess whether...
Rose didn't answer our other question about the surprise. You left us hanging, Rose. But she says, why does Roberta Glass hate Kate so much? I think I didn't know she did, but I think she has envy issues. So
the defendant may call Mr. Green to testify to these two debunked claims in her second trial. But notice, put a pin in this as well. The only parts of his testimony that they want excluded, they don't want him excluded as a witness altogether. They only want him excluded with regard to these two specific points regarding Jennifer McCabe's phone. Exactly, Jeff, Sneaker Arena, that's what I'm asking you. He also testified about John O'Keefe's phone and the Apple Health data contained therein and the GPS points, the going up and downstairs and things like that.
Well, again, just to repeat what I said before, Brennan does not have to show or nor want to show his whole hand now, just like he didn't before. So let's go back to the Dauber hearing request for Dr. Russell and the motion on that. When we read that, and I read it on the show, it had basically all the same stuff that had been initially raised by Lally back in the voir dire back in May or June. But when it got to the actual Dauber hearing, that's when Brennan and that's not even done yet because they ran out of time. But that's when Brennan started revealing his new stuff that he had. So he's keeping his ammo dry, basically. And so here he's just doing it up to get the Dauber hearing. So we're not going to know all the stuff that he's going to point out that's a problem with. We got a good sense of it though here, but we're not going to know all. He only wanted to give you just enough. And I also disagree with Melanie here, although I don't know. And people had already raised this question here. So are they trying? Well, no, actually, I believe it said right in the document that they're trying to exclude Rich Green from testifying. So I could go back and read it again, but I believe no, they're trying to get rid of Rich Green. They don't. I don't think they just want to hold a Dauber hearing to get Rich Green to change one part of his testimony. That'd be crazy. All right, so I think we're done with Melanie. Yes, I was terrified, dude. All right, so we're getting close to 10 o'clock here. And this is, even though last night's was a short show, last night's show was actually longer than I wanted to. I didn't even want to go on last night. But then when I found out about the funeral stuff, I was pretty angry about it. So I said, I'm going to do a 5-minute show. And I stayed on maybe 20 minutes or something. But still, this is 3 nights in a row. So I do run out of voice power. So if you have any good questions, throw them here now. And we'll take them on as best we can. 227 has been debunked by not only by the best experts, but by logic alone. Doesn't even really seem, to me, it's kind of like trying to prove that the world is flat. It's like, do I want to spend a lot of time on it? It's a religious belief at this point. People believe it just because they want to believe it, and that's it. Mooper, if you could do me a favor and just email me at Leitzkev, Leitskev. If you have time, please just send me an email and leave that subject alone if you could, and I will talk to you after the show via email, if that's all right with you. I mean, there's no question that Karen also asked. Thank you, Thomas. Karen also asked the paramedic on the ambulance. What's that? Probably about 20 minutes later, the same question. How long would it take someone to die in the cold? That should end the discussion for any sane person. For any sane person, that ends the discussion. Okay. But there's a lot of other reasons that 227 just doesn't even make any sense. So, unsure in the book, Jen. So, the publisher doesn't want to publish it till after the trial. So, it may not be till after the trial. If we go with the publisher, it'll be after the trial. He's given me permission to just self-publish it before the trial. So, that's another option. Fabio, Jesus. Isn't that long-haired guy? Yeah, I'm pretty much the opposite of Fabio. Wasn't it that guy from like the 80s? The long-haired dude? I'm definitely the opposite of that guy. Oh, thank you, Jay. Celtics win. Big game tonight, Minnesota, right? So I gotta see that one on replay. Thank you for the update. Tom Fleming, you let me down. You're supposed to update me on that, but Tom Fleming's absorbed with college football today. Just saying 227 happened, it just sounds like you're saying Hail Mary, full of grace. It's just a mantra. It's not an actual argument. And it's not anything that any sane person believes. 118, 115. All right, good game. The Harlequin romance novels, yeah. I remember that. Yeah, like the long-haired kind of back when the barbarian look was in. Mooper, Mooper, please do me a favor. Drop the subject and email me. Okay? If you can do me that favor. Can I ask you that favor? Is that okay? Are you okay with me asking a favor for you? Please drop that subject and just send me an email and we'll talk about it. Bruins just lost 2-1. Chick must be double watching here. She's watching. Actually, if you're watching Turtle, isn't it private night? So you must be a paid member of Turtle Boys thing for like $15 a month. Wow. But she says TB is spewing more lies. Hank Brennan afraid to fight Karen Reed because he knows the facts are all on her side. He knows better. Curious about the defense response to the motions will be. I mean, they're going to basically argue that they have the right to bring in their own experts and let the fact finders, the jury, decide. That's what they're going to say. So Jay is asking if Hank is going to bring in the ARCA guys, and that's it. We don't know, and that's a really good question too. Will he want to bring them in? Will they say the same thing? If these ARCA guys never had the vehicle data, but there's a real strong tendency for anybody, like I said earlier, to dig in their heels, to not want to change their conclusions. But at the same time, people have reputations that matter to them. And the evidence is so compelling here. These guys don't, they're intelligent guys. They don't want to be known as the guys that completely misinterpreted that data or that evidence that they had. So I don't know. I'd be curious to see if the ARCA guys can even be called on here. But there's a whole kinds of issues here in terms of their credibility, what in terms of the U.S. attorney. There's a lot of signs of corruption here. I think that's correct, TYJ. There's a chance where they get to Brennan gets to dismantle, and not Jackson. You mean he's not going to dismantle the Jackson. No, no one's going to dismantle Jackson. Jackson's a very good lawyer, and they're arguing with each other. Anyways, they're each questioning witnesses. Jen says, "Do I think anything from the FBI investigation will be let in this time?" No, because anything that was exculpatory was all they really were able to provide. I think most of those pages were grand jury testimony. I'm probably 98% of what was in was grand jury testimony. I don't know that. I'm just guessing. Does everyone now think they're an expert on Karen Read? Well, everybody has their opinions, right? And I hate to do this, Mooper, but I asked you, and I know you just made a very generous donation, and I'm happy to give it back. But I have to put you in timeout because I've asked several times now to drop it as a favor, and you refused. So that's where we're at. So you're in timeout now. I don't know how those timeouts last, like a half hour, an hour. I asked you to drop it. Okay. So I will try to figure out if you want to go in and how to give your donation, your generous donation back. But I asked you to drop it, please. And you wouldn't listen. So. All right. So let's just finish on one thing. So an email from someone that I got named Walter, who is a free Karen Read person and claims to be an engineer. I don't know, can be a little bit crazy, but he told me today that I'm not going to share the whole because it was so brief. I'll just say what he said. I don't screenshot things like this, so I'm just talking about it. He says, "I'm sorry that it has come to this, but I have now reached the conclusion that you are likely part of the corruption in Canton, Mass. Your latest video is just sad." Now, my latest video was just, all I did was ask these people not to go bother a funeral. That's it. Very short video, and that's it. And then he followed that up by saying, or maybe you are just the useful idiot. So what I basically told him, I said, "No, it's a new year. I'm trying to be nice to you." I've explained my history to the case. Now, there are some people, if they're still up, that have been with me now since the beginning of my coverage on this case. And that would be, for instance, Colin Forrester, obviously Tom Fleming. But there aren't many people here that remember what it was like back then. Maybe Ashley St. Angelo might have been around then. I'm not sure. But so what happened was April 18th, I wake up to messages from 3 people, I think, 2 connected law enforcement and 1 a good friend saying, "You got to go to this story." And they all texted me the link to this story. And it was to the one there was the first story in TB Daily News on this case. And so I went to it and I was intrigued. I had never been to his website. I had heard of him, but I'd never heard him speak or knew nothing about him. And as I was reading that story, I am first of all, I'm a complete neophyte, right? I know nothing about so many aspects of this process. I'm not former law enforcement. I'm not a lawyer. I had investigated some true crime cases, but not even that big. So I wasn't even that big into true crime. I know nothing about forensic data. I know nothing about autopsies. I know nothing about how the state police investigations are constructed. And so I'm ignorant. But I'm a fairly logical person. Looking at this, I can see right away that this is a defense theory. This is not the result of some investigation by Turtle Boy. That doesn't mean it's wrong, but I'm like, this is so you have to have a healthy amount of skepticism when you're being fed something that is a defense theory. Just because everybody that is up for murder has a clever defense team that puts together some kind of theory. We saw this with Richard Allen and Delphi. We saw with O.J. Simpson. It's the norm, right? It's the standard. But I looked at things like the 227 thing was big to me because I, at the time, thought data was just data. I didn't think that data was going to be something that the prosecution was even going to dispute. I thought it was just what was found on her phone. And if she had made that search at 227, there was no innocent explanation for that. So I was like, wow, there must be something going on here. And so I began a series on the channel called Framed with a question mark. And again, this is pretty early on in the process for me on this channel. At this point, I think the channel was about a year and a half old, not even quite that, but I had never done live videos on this channel, or really on any channel except a couple of sports channels that I had guested on for something else. And so I had no experience with running my own live shows. I started this series. Framed was something that I would script. I would research it, script it, record it, and then edit it, add some images, some clips if I had them, things like that. In just my amateur way. I'm not Microdots. And I'm not Kate Peter either. I don't have the skills that they have. And so I'd put these up. And I was maybe doing, I don't know, a couple of weeks. And so, but my whole thing was framed. Again, asking tough questions about the prosecution, but also questions about the defense theory. But more harder on the prosecution because to me, there's got to be a conspiracy here because of 227. Now, I'm not, unlike what this guy says, I had never been to Canton. My first visit to Canton and my only visit to Canton was this past April. I don't just mean Canton. I mean that area. I had never been to Dedham. I lived north of Boston and I owned a bar in Worcester for like 20 years. That's Worcester. I lived in Boston for a few years, but I lived in Charlestown and briefly in Somerville. So I have no connections at all to the Canton area. I have no connections to the McCabe's, the Alberts, the Proctors, any of that. Now, eventually I would develop friendships with some people connected to them much, much later. But when I started covering the case, no. And I'm not an investigative reporter. I wouldn't even know how to be one. I don't even know how. I don't reach out to people. I never reached out to anybody. So, it doesn't seem frozen on my end, Tom. So it might have been in yours, hopefully. But so, all right. So then I'm not sure which hearing was. I think it was probably June. I can take these off. I think it was probably June when there was a hearing and Adam Lally explained that the state has an independent data expert, forensic data expert, who turned out to be Jessica Hyde, and she was explaining that search did not take place at 227. Now, I didn't look at that and say, oh, okay, the state must be right. No. But now to me, this is disputed. It started opening my whole analysis or my opinion on how data works on forensic data, right? Now I started realizing this is something that might be open to interpretation, right? And so instead of just data is just data, now I'm like, this is something that people can argue. And so that increased the questions that I was asking on the defense theory, because now it's not that I believe the state at that point, but now 227 was no longer certain. So it's something that's up in the air. And if it's up in the air, you got to really look closer at all the other evidence. And there were the questions that I had been asking before that just kept coming harder and harder, because it doesn't make sense that you're going to put someone out alive to die on your own lawn. That never made sense. And there's many other, it doesn't make sense that Jen McCabe and Matt McCabe are going to go home knowing that that's the plan and just calmly go to bed and make that search. It's crazy. It doesn't make sense that Jen McCabe would take the call from Karen and go back to the crime scene. It's nuts. It also doesn't make sense that Jen McCabe would try to somehow cover up that data by making that search again at 623 and 624. That's crazy. So more likely, all three searches just took place at the same time. So, but this is the process that I went through. But by that time, I had added a couple of co-hosts with me that I really enjoyed their friendship. But also I had a team of, I don't know, maybe a dozen people, and we would meet in Discord, and we were planning other projects. And for someone who is struggling to get YouTube channels going and other projects going and writing gigs going, it's a struggle. And I worked very, very hard at it for a long time, thousands of hours. And so to have something work felt good. And I liked all those people, and I liked having that team, right? But they were all free Karen Reed, except for Tom, who's an old friend. But all those people had joined this team because of their sense that I was free Karen Reed. And they weren't happy that I was asking questions. They accepted it. They respected me for it. But the other side, the free Karen Reed crowd, was getting uneasy. Because at the time, they were pretty much the only two people covering this case were me and Turtle Boy. That's it. I know Jelly did a video like in July, and his videos normally would get a couple hundred views. That one did get like 7,000, but I don't think he became regular right away. So it was just, and Kate had done maybe Kate was doing like a video a month, and most of it was on other topics. So she was behind the scenes investigating it. I didn't know Kate. I'd never met her, didn't know anything about her. And so really it was just my channel and Turtle Boy that were covering this case. But people in the Facebook group that were getting very upset that I was asking these kind of questions, and they were getting nasty. And people on my side, on my team, were getting anxious. They knew what this turtle mob was about. And I said, I'm not going to stop asking questions. That's just not my nature. I'm going to keep asking questions. Very, very lonely position. They got lonelier and lonelier. But I'm stubborn like that, And then finally I had that outburst episode with Turtle Boy. That was like, I think the end of August, so 2023. And that was a turning point, obviously. I lost 40% of my subscribers in like an hour. But more than that, really lost like 95% of the audience and all of the donos. And that month we had got like $1,200 in donos. So that was all used to support projects on the channel. But I lost all that. And so, that obviously that stinks. And spider. So that's where it was. And then inevitably I did lose all of my team and my co-hosts. The only one that stayed loyal was Tom. And Tom doesn't really care that much about this case. So it's not something, I think Tom kind of leaned somewhat free Karen Reed, but in an agnostic way, didn't really care and didn't want, I hope that's a fair way of describing it, Tom. And, but everybody else was free Karen Reed, and they all left. And so we had to kind of regroup here. And as part of that process, I kind of went off the air. I didn't do any shows for a couple of weeks. Then when I came back, I had some authors from other books and stuff like that I would do shows with them. But, I think when I first came back, have like 20, 25, 30, 35 viewers. So definitely starting from the bottom and slowly working my way back up a little bit. And then, but it was during that time that people reached out to me, such as Kate and other people from the Canton area. But they don't manipulate me. They have discussions with me. And honestly, they really, the one thing that Kate gave me was documents. And I have developed other ways to get them since then. But back then, that was when she called me, that was the first thing I wanted to know. Can you get me documents? I want to read documents. Turtle Boy would never share documents. Karen never shares documents. They want to monopolize it. They want to highlight something for you to read. And that's it. I had asked Turtle Boy, first time I chanced to talk to him, can you get me documents? Oh, no, well, no. Bottom line is he didn't want to share them. He wants to monopolize them. So So that's it. It's not like these people were sending me discovery material. Nope, never. And over time, as the way it would develop, you just kind of say, people like, say, Chris Albert, he's not feeding me any information. He's calling to see what I've heard, and then we just talk about the case sometimes. That's it. So there was the idea that this guy said that I'm in the tank for these people and I've been corrupted. No, it's crazy. It never was like that. And the people like Grant that think I get my marching orders from Kate every day or something. It's not. You're obviously not paying attention to how I am. I don't take marching orders from anybody, and Kate doesn't give marching orders to anybody. It's not like that. These people have these kind of delusional theories. Tom CPU was saying on his show today, I guess that what I said last night I got from Kate. No, about the funeral stuff. No, I did not. And he had a show scheduled for 10 o'clock this morning, which he canceled. And that was the exact same time as the funeral, 10 o'clock. So that's how it is. I'm not in the tank for anybody, and they don't want me to be. Nobody's ever insisted or asked me to report anything. They want me to do what I'm doing, which is to discuss the case objectively. They don't want me to push some kind of a party line. They want the truth too on all these different things. That's the thing that has stood out to me in all my conversation with Chris, is he just kind of wants to know the truth. He wants to know what has happened here. He can't explain everything either. He just knows that his son wasn't there and John never went in the house. That's all he knows, The rest is just trying to figure out what went on here, And of course, and as it's developed, the thing that we most need to figure out is what went on with the feds. Why did they corruptly get involved here? So that's that. That's where we'll leave that on that. And we did make it to 10, another 2-hour show. Thank you very much, guys, for being here. Appreciate it. Just seeing the last couple of comments, but that's it. That's how I roll. And occasionally, if I lose my temper or get upset, it doesn't happen often, but I'm not going to stop being who I am. Not that I'm always right for getting mad. No, I probably should never do that, but you have to be who you are too, So, so I think it's important, but thank you guys. Jen, and the last few comments here, Ashley, Miss J, Chick from the Bricks, Nicole, all saying good night to you guys too. Thank you very much, and enjoy the great weather. I think we might have some snow coming Sunday night or something like that. I hope so. I love a good snowstorm. So